First over other idea.
That's kindly. Serial number 71 Mala. 71 Mala. Rajagopal appearing on behalf of the appellant Mala. Use this art accommodation has to be.
Okay.
Incomplete one day or three.
Other side are.
Inform ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್ ಸೀನಿಯರ್ ಒಂದೇ ಒಂದು ವಾರ 71 ಮಲ ಈಸ್ ಅಪಿಯರಿಂಗ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದಿ ಅಪ್ಲೈಂಟ್ ಮಲ ಎಂ.ಆರ್. ರಾಜಗೋಪಾಲ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್.
ಯಾರ ವಿನಾಯಕ ಬಿ ವಿಷ್ಣು ಭಟ್ಟ ಅಂತ ಯಾರು ಇದಾರೆ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಾರಂತ
ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕನ್ಫರ್ಮ್ ಇದ್ರೆ ಕೊಡ್ತೀನಿ, ಇದ್ದವ್ರಿಲ್ಲ. ಕೇಳಿದಿರಾ ನೀವು ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಾರಾ?
ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇಂಟಿಮೇಷನ್ ಮಾಡ್ತಾರೆ
ಅವ್ರು ಬಂದು ಆಮೇಲೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ಕೊಡ್ದು ನೋಡಿ. ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ನೀವ್ಯಾರಿಗೆ?
Number 74.
ಇರಿ ಒಂದ್ ನಿಮಿಷ ಇರಿ
Please.
Counsel for the proxy counsel Sri Raju submits that senior counsel Mr. M.R. Rajagopal appears on behalf of the appellant in RSA number 1037 seeks time and also submits that he had communicated him that he had already intimated counsel for R123.
ಈಗಲೇ ಮಾಡ್ತೀನಿ.
ಈಗ ಮಾಡೋದಾಯ್ತು. ಅವ್ರು ನಿಮಗೆ ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರ ಅಂದೆ?
ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ಯು ಮಸ್ಟ್ ಬಿ ಫರ್ಮ್. ಎಂ.ಆರ್. ರಾಜಗೋಪಾಲ್ ನಿಮ್ಗೆ ಹೇಳಿದ್ರಾ ಅದರ್ ಸೈಡಿಗೆ ನಾನು ಹೇಳಿದೀನಿ ಅಂತ?
ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರಾ? ಅದನ್ನೇ ನಾ ಬರ್ದಿದ್ದೀನಿ ಅಷ್ಟೇ. ಏನಾಯ್ತು ಮೇಡಮ್? 1 to 3 and hence list this matter on ಕೊಡಿ. ಯಾವಾಗ? 21 matter suit for partition.
one week sir.
10/7.
1 week sir.
1 week ನಿಮ್ಗೆ ನಮ್ಮಲ್ಲಿ ಜಾಗ ಇರ್ಬೇಕಲ್ಲ. ಹೇಳ್ರಿ. 71 ಯಾವ್ದು? 74. ಏನಾಯ್ತು? ಮಾರ್ನಿಂಗ್ ಯಾರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ಏನಾಯ್ತು?
We informed the other side during lunch.
ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? ಕೌನ್ಸಿಲ್ ತಗೊಳ್ಳಿ. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ seeks time and also submits that already intimated counsel for the respondent. ಲೀಲಾಧರ್ ಇದಾರೆ, ಶಂಕರ್ ರೆಡ್ಡಿ ಇದಾರೆ, ಇಬ್ರಿಗೂ ಹೇಳಿದಿರಾ ಏನು?
Informed Mr. Leeladhar.
ಲೀಲಾಧರ್ ಯಾರ? ಶಂಕರ್ ರೆಡ್ಡಿನೂ ಇದಾರಲ್ಲ.
Contesting response Mr. Leeladhar.
ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ನೀವು ಅವ್ರಿಗೂ. Intimated the counsel for R1 and also undertakes to intimate counsel for R2 and hence list this matter. Yav date kotti madam inno? 10/7.
Please.
My lord, very next matter.
ಯಾವುದು?
63.
ಹೇಳಿ ಏನಾಯ್ತು?
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ HRCRP 2 of
ಇದಾರಲ್ಲ ಇಲ್ಲೇನೆ
2 of 21 ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್. ಸೊ ಅಲಾಂಗ್ ವಿತ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
2 of 21 ಗೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಇಂಡಿಪೆಂಡೆಂಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬೇರೆ ಬೇರೆ?
ಇಲ್ಲ, ಇಂಡಿಪೆಂಡೆಂಟ್ ಇದು ಬೇರೆ ಬೇರೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆದ್ರೂ ಸೇಮ್
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆದ್ರೆ
ಸೇಮ್ ಪಾರ್ಟಿ
ಸೇಮ್ ಇರ್ಬೋದು. ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಒಂದ್ ಬೇರೆ ಬೇರೆ. ಹೌದಾ?
ಎವಿಡೆನ್ಸ್ ಬೇರೆ ಬೇರೆ.
ಆಯ್ತು. ಎವಿಡೆನ್ಸ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಇದ್ದಾಗ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಅದನ್ನ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕು.
ಹೇಳಿ. ಆಲ್ ರೈಟ್, ಮೈ ಫರ್ದರ್ ರಿಕ್ವೆಸ್ಟ್ ಯುವರ್ ಆನ್ಸರ್ಸ್ ನೆಕ್ಸ್ಟ್ ವೆನ್ಸ್ಡೇ ಅರ್ಥ ಅಷ್ಟೇ.
Appellant counsel revision petitioner counsel seeks time. Counsel for respondent says no objection. List this matter on ಯಾವ್ದಾರು HRRP old matter 21 ಕೊಡಿ. ಯಾವ ವರ್ಷದ HRC? 21 ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ. HRRP 21 ರೀ. HRC ಯಾವ ಇಯರ್ ಅಂತ ಕೇಳಿದೆ.
ನನ್ನ ಪೇಪರ್ಸ್ ಎಲ್ಲ ತಗೊಂಡೋದ್ರು. ಹಾಗಾಗಿ
ಬಿಡಿ ಮೇಡಮ್ ಕೊಡಿ. ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಎಷ್ಟು? 7/7 ಆಯ್ತು. ಅವತ್ ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ಬೇಡಿ. ಅದನ್ನ ಹಾಕ್ಬೇಕಾ? ಇನ್ನೊಂದು ಯಾವ್ದೋ HRC
ಅಲಾಂಗ್ ವಿತ್
ಅಂತ ಬರಲ್ಲ, ಅದನ್ನ ಅವತ್ತೇ ಪೋಸ್ಟ್ ಮಾಡೋಣ. Counsel for the appellant revision petition submits that HRRP number 2/21 is also between the same parties and the same also may be listed and hence list the same also on 7/7.
Passed out matter list 1 serial number 1 Vinay Kirtiyam
respondent number 2
amendment ಮಾಡಬೇಕಾಗಿತ್ತು. ಬೆಳಿಗ್ಗೆ ಇರಲಿಲ್ಲ ಸರ್.
ಏನಾಯ್ತು? ಈಗ ಮಾಡಿದ್ರ ಅಮೆಂಡ್ಮೆಂಟ್? ಇಲ್ಲ. ಯಾವ ವರ್ಷದಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ರು?
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
13/12/24 ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ. ಕಾಸ್ಟ್ ರೈಟ್ ಲಾಕ್ ಇಲ್ವಾ?
ಅಲ್ಲ, ನನಗೆ ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ.
ತಗೊಳ್ಳಿ. This court wide order dated 13/12/24 ಯಾವುದು ಬೇರೆ ಕೊಡ್ತಿರಲ್ರಿ ಮೇಡಮ್?
ಇಲ್ಲ ಸರ್, 4/9/24 ಫಸ್ಟ್
ಅಲೋ ಆಗಿರೋದಾ? ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದ ಅದಾಲತ್ ಅಂತಿದೆ ಮೇಡಮ್. ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? Accordingly, A number 1 of 24 is already amend the cost rate. Third, This court wide order dated 4/9/24 allowed the A number 1 of 24 and directed the appellant counsel to amend the cast title and filed amended appeal memo. And the same is not carried out and also filed amended cast title. And again on 13/12/24 given time to do the needful. And once again 4/9 adena 13/12 ಆದ್ಮೇಲೆ 13/12 ಆದ್ಮೇಲೆ ಮತ್ತೊಂದೇನು 4/9 ಹಳೇದ 4/9
ಹಳೇದು 4/9.
ಅದು ಹಳೇದ ಅದು ಆಯ್ತು.
4/9.
Once again 13/12/24 also week's time was given till date not amended the cast title and not filed amended cast title and hence on cast and this matter is called twice in the early morning and also in the afternoon and no representation and hence on cast of rupees 1,000 1 week time granted to amend the cast title and file amended cast title. If fails to do the same, appeal will be dismissed in the next state of hearing. List this matter on 1 week.
My lord, one submission. There be direction to the appellant to serve the copy on the appeal memorandum.
ಯಾವ್ದು ಕಾಪಿ ಸರ್ ಮಾಡಿ
ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ ಏನು?
ಹೌದಾ ಏನಾಯ್ತು ಮೇಡಮ್? List the matter. At this juncture, counsel appearing for the R2 also submits that even appeal memo copy is also not served and hence counsel for the appellant is directed to serve the same forthwith. ಇದೇನು ವಿನಯ್ ಕೀರ್ತಿ and GM ಶರತ್ ಕುಮಾರ್ ಒಟ್ಟಿಗೆನಾ ಎರಡೂನು ಕಂಬೈಂಡ್ ಅಥವಾ ಏನಾರು
ಇರ್ಬೇಕು ಸರ್, ಒಟ್ಟಿಗೆ ಇರ್ಬೇಕು.
ಒಟ್ಟಿಗೆ ಇದೆಯಾ ನೋಡಿ
ಒಟ್ಟಿಗೆ ಇರ್ಬೇಕು ಸರ್.
ಒಟ್ಟಿಗೆ ಇದೆಯಾ
ಹೌದು.
ಆಯ್ತು. forthwith furnish the copy of the appeal memo forthwith. ಆಯ್ತು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ನೆಕ್ಸ್ಟ್ ಟೈಮ್.
Sir, list on 3/7.
ಲಿಸ್ಟ್ ಆನ್ 3/7 ಹಾ
15
15
B Vinod Reddy.
ಹೇಳ್ರಿ ಅದು ಏನು ವಿನೋದ್ ರೆಡ್ಡಿ
1/5.
non compliance of office objections
My lord, kindly
non filing of acknowledgement for having paid the cost ha ಏನಾಯ್ತು
paid the cost, my lord. Only,
cost paid
yes, my lord. Only 2 days time may be granted.
ಮತ್ತೇನು
my lord, to
ಟೈಮು
comply.
counsel submits that he paid the cost today in the office and also filed memo along with cost receipt. Office objections ಏನಕ್ಕೆ ಇರೋದ್ರಿ?
My lord, pagination ಒಂದು ರಾಂಗ್ ಆಗಿದೆ ಅಯ್ಯ ಕಾಪಿ ಮೇಲೆ ಅಂತ.
ಅದು ಈಗ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ ಬೆಳಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಆದಾಗ ಫೈಲ್ ತಗೊಂಡು ಪೇಜಿನೇಷನ್ ಮಾಡಕ್ಕೇನು ಇನ್ನೊಂದೇನ್ ಮಾಡ ಇನ್ನೂ 4 ಇದೆಯಾ?
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ ಒಂದು
ಎಷ್ಟನೇ ಸರಿ ಲಿಸ್ಟ್ ಆಗಿರೋದು ಇದು?
2 ಸಲ.
ಕೊಡಿ This appeal was filed on 7/12/1920 sorry 7/12/2020 and matter was listed before the registrar on 4/11/22. Kamaki 3/8/23 ಎಂತ ಎರಡು ಸಾರಿ 3/8/23 ಏನ್ರಿ 3/8/38 ಅಂತ ಮತ್ತೆ ಇದೆ ಇಲ್ಲ ಇದು ಒಂದು 3/8 ಅಗೇನ್ 3/8 4/8 ಅಂತಿದೆ ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ನೋಡಿದ್ರೆ 4/8 ಇದೆ ಇಲ್ಲಿ 3/8 ಇದೆ ಒಂದೇ ಹಾಕ್ಬಿಡಿ 3/8 ಮೋಸ್ಟ್ಲಿ ಅದು 11/8 ಇರ್ಬೇಕು ಮೇಡಮ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಇಲ್ಲ ಮತ್ತೆ ಮ್ಯಾಟರ್ ಲಿಸ್ಟೆಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಆನ್ 11/8/23 ನನ್ನ ಮುಂದೆನೆ 23ನೇ ಇಸ್ವಿಲ್ ಬಂದಿದೆ ಆಗ್ಲೇ ನಾನು 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕಿದ್ದೀನಿ.
One day, my lord, I will.
ಡಿಸ್ಮಿಸಲ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತ 11/8 ಮಾಡಿ 28/8/23 ಕೊಟ್ಟಿದ್ದೀವಿ. Urgent on cost of rupees 500 and order to list the matter for dismissal on 28/8/23. On 28/8/23 once again counsel sought time and this court granted on further cost of rupees 500 and again listed on 9/1/24 and none appears. However, on further cost of rupees 1,000 2 weeks time was granted. And on 37/24 once again finally 2 weeks time granted. And in spite of costs are imposed on 3 occasions and paid the cost not complied with office objections again 6 time and hence on further cost of rupees 5,000 5 ವರ್ಷ ಒಂದು ಕಂಪ್ಲೈನ್ಸ್ ಗೆ Another 1 ವಾರ ಬೇಕಾ 2 ವಾರ ಬೇಕಾ? 5,000 ಹಾಕಿದ್ದೀನಲ್ಲ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಇನ್ನೂ ಲಿಬರಲ್ 2 ವಾರ ಅಂದ್ರೆ
2 weeks.
ಆ?
2 weeks, my lord.
2 weeks time granted. If cost not paid and not complied with office objection, appeal is dismissed without reference to the bench.
16. Kalyan Basvraj.
ಅದು 5,000 ಇರೋದು 2,000 ಮಾಡಿ ಮೊದ್ಲು 2,000 ಕಟ್ಟಿದ್ದಾರೆ. ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್ ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಏನಾಯ್ತು ಬೆಳಗ್ಗೆ ಏನು ಬರ್ಲಿಲ್ವ ಯಾರು ಹಿಂದಿನ ಕೊಡಿ. This court
appellant in this matter.
issued the notice on 12/3/24. ಹೇಳಿ ಏನ್ ಮಾಡಿದೆ?
Taken necessary steps. Done the needful, my lord.
ಯಾವಾಗ?
ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ದೀನಿ, my lord. I will furnish the process.
ಅಲ್ಲ ರೀ 12/3/24
Morning it was passed over.
ಒಂದೂವರೆ ವರ್ಷ ಬೇಕಾ ನಿಮಗೆ PF ಕೊಡಕ್ಕೆ? ಆಮೇಲೆ ನಾವು ಕೇಸ್ ನ ಕರೆದು ಇಟ್ಕೊಂಡು ಆಮೇಲೆ ನಿಮ್ಮ ಹತ್ರ PF ಕೊಡ್ಸ್ಕೊಂಡು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾ?
It is paid, my lord. I furnished.
ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? 12/3/24 and counsel in the afternoon submits that he has paid the PF today in the office and hence issue notice against the respondent. ಬರೀ ಅದು A number 1 of 21
ಹೌದು ಸರ್.
ಏನದು A number 1 ಡಿಲೇ ಆಫ್ 2,141 ದಿವಸ ಇವತ್ತು PF ಕೊಟ್ರಾ? ಕೊಡಿ ಡಿಲೇ ಮೇಲೆ ಹೇಳಿ ಏನದು ಡಿಲೇ ಮೇಲೆ ಹೇಳಿ ನೋಡೋಣ. 2,141 ದಿವಸ ಇದ್ದಾಗ ಡಿಲೇ ಮೇಲೆ ಯಾಕೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು? You first convince the court.
My lord, I will convince, my lord. Senior will.
First you convince the court counsel. Suit of the plaintiff is dismissed. Appeal is also dismissed and confirmed. ಯಾಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಯಾಕೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಅವ್ರನ್ನ ಕರ್ಸ್ಕೊಂಡು ಅವ್ರು ಮತ್ತೆ ಬಂದು ಲಾಯರಿಗೆ ಫೀಸ್ ಕೊಟ್ಕೊಂಡು ಕೆಲಸ ಮಾಡ್ಬೇಕು? ಹೇಳಿ ಫಸ್ಟ್ ಹೇಳಿ ಡಿಲೇ ಮೇಲೆ ಹೇಳಿ ಏನ್ ಡಿಲೇ?
Senior will argue influence, my lord.
ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್?
All inconvenience, my lord. Small inconvenience.
ನೋ
not in town, my
ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
lord.
ಹೇಳಿ ಫಸ್ಟ್ ಆರ್ಗ್ಯೂ. ಐಎ ಮೇಲೆ ಹೇಳಿ. ಐಎ ಮೇಲೆ ಯಾಕೆ ಸೀನಿಯರ್ ಹಾಕ್ಬೇಕು? ಜೂನಿಯರೇ ಸಾಕು. ಅಫಿಡವಿಟ್ ಓದಿ. ನಮ್ ಕೋರ್ಟ್ನವರು ಕಣ್ಮುಚ್ಕೊಂಡು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ 2,000 ಡಿಲೇ ಇದ್ದಾಗ ಅವ್ನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾಕೆ ವೈ ಹಿ ಹ್ಯಾಸ್ ಟು ಎಂಗೇಜ್ ದಿ ಕೌನ್ಸಿಲ್? ಅಲ್ಲೇ ಸುಣ್ಣಾಗಿರ್ತಾನೆ 2 ಕೋರ್ಟಲ್ಲಿ. ಇನ್ ಇಲ್ಲಿ ಬಂದು ಇನ್ನೊಂದ್ಸರಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಇನ್ನೊಂದ್ 4 ಗುಂಟೆ ಜಾಗ ಮಾರ್ಬಿಟ್ಟು ಬರ್ಲಿ ಅಂತಲೇನ ಲಾಯರ್ನ ಎಂಗೇಜ್ ಮಾಡಕ್ಕೆ?
Short accommodation may be made, my lord. I will.
Sorry, the counsel submits that he has paid the PF and on perusal of the order sheet, notice was ordered on 12/3/24 and there is a delay of 2141 of 2,141 days and also having perused the records, concurrent finding and second appeal is filed against the concurrent finding and question of issuance of notice doesn't arise. List this matter on date kodi
8/7
to convince this court with regard to the delay of 2,141 days. Notice ಏನು ಕೊಡೋದು ಬೇಡ ಮೇಡಮ್?
40. PM Sidmalappa.
My lord, I pray for the respondent, my lord.
Appellant.
My lord, my humble submission, my lord.
41
40,
sir.
40, my lord.
40 ಹೇಳಿ.
My lord, sorry, my lord.
Ah.
In the morning, my lord, I have received the application, my lord.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
Regarding the withdrawal of
Liberty
the.
to file a
ಇದ್ರಲ್ಲ
Today morning, I have received, my lord. But my lord, I have no objection, my lord, to, my lord, let them withdraw the appeal, my lord. But keeping all the issues, my lord, even the limitation also, my lord.
kept open.
Kept open.
ನೀವು objections ಹಾಕಿದಿರಾ?
ಇಲ್ಲ. To the, only to the.
ಈಗ objections ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, ಸ್ವಾಮಿ.
ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಸ್ವಾಮಿ.
Appellant counsel filed an IA 1 of 22 for withdraw the suit. And in the application, while seeking the withdrawal permission, sought the permission to appellants to file a fresh suit for declaration and for recovery of possession. The counsel appearing for the respondent submits that IA may be allowed, keeping open all the objections.
Issues, my lord. All the
Issues.
Issues.
And in view of the submission of the counsel and also the prayer sought in the application, permitted to withdraw the appeal with liberty to file a fresh suit as sought in the appeal, and all objections are kept open.
My lord, even the limitation also, my lord, limitation.
ಎಲ್ಲಾನು objections are kept open ಅಂದ್ರೆ limitation ಸೇರುತ್ತೆ, ಎಲ್ಲ ಸೇರುತ್ತೆ.
Please, my
ಹಾ.
lord, please. Grateful. Much obliged.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿ. 50. ಮೋಹನ್ PM.
ಏನ್ರಿ ಇದ್ರಲ್ಲಿ? Why it was passed over?
My learned friend wanted pass over, and also not in the cause list. A second matter really, not we have
ಏನು
served.
non
not-
furnishing of copies served acknowledgement of appeal memo as per order dated 3/6/25. ಏನದು 3/6/25 order?
625 leave, voted directed that we serve the council. ಇವರಿಗೆ serve ಮಾಡಿದ್ವಿ, but ಇನ್ನೊಬ್ರು lawyer ಇದ್ದಾರೆ, ಯಾರು ಅಂತ we are not able to.
3/6/25. The learned counsel for the appellant has filed memo along with paper publication ಎಲ್ಲ ಆಯ್ತದು. The learned counsel error Shrikara. Accepted to take notice for respondent number 5 and 6 in RSA 566/21. Since appears in connected matter on behalf of the respondent number 5 and 6. The counsel ಯಾರ ಸೈಯದ್ ಅಮೀರ್.
ಹೌದು, ಅದು ಯಾರು ಅಂತ ನಮಗೆ ಗೊತ್ತಾಗಿ.
He directed to take notice for respondent number 7 and 8 in RSA number 566/21, 7 and 8 ಗೆ. Since he appears in connected matter in respect of very same respondents ಅಂತಿದೆ. Connected ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರಂತಲ್ಲ ಇವ್ರು.
ಸೈಯದ್ ಅಮೀರ್ ಇದ್ದಾರೆ.
ಸೈಯದ್ ಅಮೀರ್ ಇದಾರಲ್ರಿ ಬಿ
ಅದ್ರಲ್ಲಿ
for R7 and R8 ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ.
ವಕಾಲತ್
ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅವ್ರಿಗೆ serve ಮಾಡಿದ್ರು, ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪೇರ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಅದ್ರಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲೂ ಹಾಕಿಲ್ವಾ? ಹೆಸರು ತೋರಿಸಿದಾರೆ ಇದೆ ಮೇಡಮ್.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್
ಸೈಯದ್ ಅಮೀರ್ ಬಿ ಫಾರ್ R7 and R8 ಅಂತ ಇದೆ. ಅದ್ರಲ್ಲಿ ವಕಾಲತ್
ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂತಾನೆ
ಹಾಕಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲೂ ತಗೊಳ್ಳಿ ನೋಟಿಸ್ ಅಂತ ಮಾಡಿದೀವಿ. ಅಂಡ್ ಕಾಪಿ ಇಸ್ ಆಲ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಸರ್ವ್ ದಿ ಕಾಪಿ ಆನ್ ದೆಮ್ ಅಂತ. ವಕಾಲತ್ತಲ್ಲಿ ಇರುತ್ತೆ, ಅಡ್ರೆಸ್ ಇರುತ್ತೆ, ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. Counsel for the appellant is directed to serve the copy of this appeal memo on the counsel Sri Syed Amir B and Sri PK Shrikara.
serve ಮಾಡಿ.
ಆಯ್ತು, ಸರ್ವಿಸ್
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು.
counsel Sri PK Shrikara submits that he has received the copy of the appeal memo in RSA 566/21. ಇದೆಯಾ ಮೇಡಮ್? ಇದೆಯಾ? ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ ನೀವು. The appellant counsel seeks time to serve the copy of the appeal memo in RSA number 566/21 to counsel Sri Syed Amir, who appears for R7 and R8 in connected RSA number 567/2021, and list this matter on ಯಾವಾಗ ಸರ್ವ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಸರ್ವಿಸ್ಗೆ?
ನಂಬರ್ ಸಿಕ್ತು, ಈಗಲೇ ಟ್ರೈ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಲಾ?
ಆಯ್ತು,
ಕೊಡಿ, ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಸರ್.
ಯಾವತ್ತು ರೆಡಿ ಇರ್ತಾರ? ನೆಕ್ಸ್ಟ್ ಡೇಟ್
I am ready.
10/7.
Lord's permit, I'll argue, I am ready.
ಅಲ್ದರ್ರಿ ಅದರ್ ಸೈಡ್ ಇರ್ಬೇಕಲ್ರಿ R7 and 8. ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿ ಮತ್ತೆ ನನಗೆ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ
Correct.
ಎಲ್ಲ ಯಾಕಬೇಕು?
Correct.
10/7.
Respondent number 3 and 4. May I request 11th, my lord?
11th ಬೇಕಾ? 10 ಬೇಡವಾ? ಆಯ್ತು, 11/7 ವರ್ಕಿಂಗ್ ಮೇಡಮ್ ನೋಡಿ. ವರ್ಕಿಂಗ್ ಆಯ್ತು, 11/7 ಫ್ರೈಡೆ.
Please.
61 BS Prasad.
BS Prasad.
This case, my lord,
Hmm.
similar case filed at some other encroaches, my lord.
Huh?
Some other person, my lord, filed a similar suit. Trial court decreed the suit. That's the reason I want to get papers in that suit. Similar set of facts, similar exhibits.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಡಿಗ್ರಿ ಆಗಿದೆ.
ಅದ ಅಪಲೇಟ್ ಕೋರ್ಟಲ್ಲಿ ಏನಾಯ್ತು?
ಇನ್ನು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿದೆ.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಅದ್ರ ರಿಸಲ್ಟ್ ಗೊತ್ತಿಲ್ಲ. And in this case also, my lord, we filed a possession and they constructed the building. That's the reason demolition, mandatory injunction. The trial court, my lord.
ಜಡ್ಜ್ ಯಾರ ಬೇರೆಯವ್ರು ಇದಾರಲ್ರಿ? ಸೇಮ್ ಜಡ್ಜಾ?
ಅಲ್ಲ, ಸೇಮ್ ಜಡ್ಜ್ ಅಲ್ಲ.
ಇಲ್ಲ, ನಿರ್ಮಲಾ MC ಅಂತ ಯಾರ ಇದಾರೆ ಇಲ್ಲಿ? ಶಿವಮೊಗ್ಗ. ಇದು ಶಿವಮೊಗ್ಗನೇನಾ?
ಸೇಮ್ ಪರ್ಸನ್, ಪಾರ್ಟಿ ಪ್ಲಾಂಟಿಫ್ ಇಸ್ ಸೇಮ್.
Suit of the year 2017.
ಅದು 2016.
16.
And mandatory injunction and the possession. But it is not the trial court stated.
Mandatory injunction and recovery of possession.
And it is maintainable. Trial court, my lord, consider that, my lord, is a declare, I have to file a declaration suit. It's a registered sale deed, my lord. We commissioner also appointed. trial court finding.
ಏನ್ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಏನ್ ಕೇಳಿದ್ರು ನೀವು?
Demolish the building, construction. Page number 37 and 38, my lord, is a finding of the trial court.
ಡಿಫೆಂಡೆಂಟ್ ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ
ಇದ್ರಲ್ಲಿ ಕಂಟೆಂಟ್
ಈ ಸೂಟ್ ಅಲ್ಲಿ?
ಆ ಸುಟ್ಟು ಕಂಟೆಂಟ್ ಇದ್ರಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದೆ.
ಹಾ. Court itself has
Stated that my lord ought to have filed
no such issue before the trial court regarding maintainability of the suit
no, my lord.
without seeking the relief of para 11 ಅಲ್ಲಿ ಅವರೇ ಒಂದು ಅಸ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡು ಏನೋ ಮಾಡ್ದಂಗಿದೆ ಇದ್ರಲ್ಲಿ.
Please.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾರು ಅದ್ರಲ್ಲೂ ಅಪಿಯರ್ ಆದ್ರೆ ಎಕ್ಸ್ಪರ್ಟ್ ಏನ ಅದುವೇ?
ಅದರಲ್ಲಿ
ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಏನ?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
It's the only possession and a mandatory injunction suit is maintainable. But the court, they are not disputing my registered sale deed. And
Defendant to demolish the illegal structure
yes,
existing in the suit property and for delivery of the vacant possession. ಏನ್ ಕಾಸ್ಟ್ suit structure ಏನಿದೆ?
structure they constructed a small building.
ಬಿಲ್ಡಿಂಗ್ ದಾ?
Small building.
ಹಾ.
Question of filing a declaration doesn't arise, my lord.
First you have to prove your property ಅಲ್ಲೇನ್ರಿ?
Yes, my lord.
ಡಿಕ್ಲರೇಷನ್ ಕೇಳ್ಬೇಕಲ್ಲ ಮತ್ತೆ ನೀವು?
They are not disputing my registered sale deed.
ಆಯ್ತು, they are placed expert. But ನೀವು without seeking the relief of declaratory relief, how can you
The
seek the relief
possession
of?
suit itself is
ಅದು
maintainable.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು ಏನು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ? ನಿಮ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಾಗ ಫಸ್ಟ್ ನಿಮ್ ಪ್ರಾಪರ್ಟಿನ ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಡ.
I proved, my lord, kindly see the same evidence, set of evidence.
ರಿಲೀಫ್ ಕೇಳ್ಬೇಕಲ್ಲೇನ್ರಿ ನೀವು?
Same set of evidence, same relief.
ಅಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿರ್ಬೋದು, ಬಟ್
Connected
ಲಾ
suit
ಏನ್
ಮಾಡಿ.
ಹೇಳ್ತದೆ?
So, but declaration suit is
ನಿಮ್ಮ ಪ್ರಕಾರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಲ್ರೆಡಿ ಮೇಡ್.
encroached and construction already made.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಅದನ್ನ ಎಷ್ಟು
ಅದು schedule ಅಲ್ಲಿ ಇದೆ. 12 into 32 plus 31 bar 2.
12 into
12 into 32 plus 31 bar 2.
ಮತ್ತೆ
Portion,
ಆಲ್ಮೋಸ್ಟ್ ಪೋರ್ಷನ್
Portion of the property. Not
ನಿಮ್ದೆಷ್ಟು ಟೋಟಲ್ ಎಂಟೈರ್ ಏರಿಯಾ ಇರೋದು?
total entire area, my lord. Different person, my lord, encroach different property.
ಆಯ್ತ್ರಿ, unless you prove that property belongs to you,
No,
seeking the relief
no
of
one is
declaration.
disputing that, my lord. Is a question of.
ಅಂದ್ರೆ ಬಟ್ ನೀವು ಫಸ್ಟ್ ಯು ಶುಡ್ ಸ್ಟ್ಯಾಂಡ್ ಆನ್ ಯುವರ್ ಓನ್ ಲೆಗ್ ರೀ
Yes,
ಫಸ್ಟ್.
yes, my lord. This, the
ಕೊಡಿ
possession.
ಕೊಡಿ, ವಿತೌಟ್ ಸೀಕಿಂಗ್ ದಿ ರಿಲೀಫ್ ಆಫ್ ದಿ ಡಿಕ್ಲರೇಷನ್.
Once it will.
ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ.
Yes, my lord. I will.
ಕೊಡಿ, ಯಾವಾಗ ಕೊಡ್ತೀರಿ?
The main.
ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ರು ಅಂತ ಇಲ್ಲಿ ಕೊಡಕ್ ಬರಲ್ಲ.
ಇಲ್ಲ.
ಲಾ ಏನಿದೆ ಅದನ್ನ ಮಾಡ್ಬೇಕು, ಹೌದಲ್ಲ?
Please.
ಇದರಲ್ಲಿ prove that defendant illegally occupied the social property and constructed Mangalore tiled house structure in the social property, whether plaintiff is entitled for the vacant possession of the social property.
In judgment, my lord, ownership is concerned, my lord.
ನೀವು ಸಬ್ಜೆಕ್ಟ್ ಅದ್ರ ಮೇಲೆ ಎರಡು ಕೋರ್ಟ್ ಡಿಸ್ಮಿಸಲ್ ಮಾಡಿರೋದು on the ground that without seeking the relief of declaration, not seek for the relief of mandatory injunction and possession ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಯಾವ್ದಾರ ಸೈಟೇಷನ್ ಇದ್ರು ಕೊಡಿ, ಯಾವತ್ತು ಕೊಡ್ತೀರಿ?
On 10 days, man.
Appellant counsel seeks time to place on record the citation regarding maintenance of the suit for mandatory injunction and for possession without seeking the relief of declaration. Hence this matter on
47.
47
Please.
47.
52. Nayak Ramachandra Ram.
Suit for partition
Hmm.
by the plaintiffs and others.
Hmm.
Plaintiff. Suit is partly decreed.
Granting 19 share in item
19
number
share
1
each of the
3 to 9 and dismissed in respect of 1 and 2.
except 1 and 2, it is dismissed. It is both the court said that that is the self-acquired property of the applicant number 1, my lord. But my lord, both the courts have relied upon the documents exhibit P15, D15 and B 21, 23, 24, 25.
Exhibit?
D15. It is D15 is the passbook of the dependent number 1, my lord.
D15, passbook of Bank of Maharashtra.
Maharashtra. But my lord, it is produced in what date? They said that prior to purchasing of this property, schedule 1 and 2, he withdrawn an amount of rupees 4,300 rupees as on the date of registration of the property. But the exhibit P disclosed.
Sale consideration ಎಷ್ಟು? Sale deed ಯಾವುದು?
10,000 rupees.
Sale deed ಯಾವುದು?
Sale deed dated, my lord, 1983.
ಮಾರ್ಕ್ ಆಗಿದೆಯಾ?
Mark ಆಗಿದೆ. Exhibit P D1.
D1
D1.
35/1983.
83.
ಹಾ.
The exhibit this is the passbook. Later, my lord, he has produced the ID card of his service. But all these documents, my lord,
Service ಅಂದ್ರೆ he was
he
working.
is working in the GKW.
ಹಾ?
GKW company.
GKW.
Earlier, he said that, my lord,
ಆಯ್ತು.
prior to purchase of this property, he is serving the railway. But wherein his eye was damaged, accident, he will leave that job and thereafter he says joined the railway society. But these two documents have not been produced before the court and it was not marked. Wherein also prior to purchase of this land, my lord, he has not produced any document regarding to his income. Only he stated that he is receiving the amount. But subsequently of this purchase, he produced the documents like this, not exhibit P15, P21, P22 and P25, my lord. Both the courts have doctrine of the presumption. The P25, my lord, it is the settlement between had given to him by the company, DKW company, in the year 2011. It is the presumption that, my lord, he is continuing in the work and he has this independent source of income. He acquired this suit schedule item number 1 and 2. But this, my lord, he has in the deposition, in between as on the day of the purchase of this property, the plaintiff number 1, my lord, is the Gopal Krishna and this dependent number 1 is jointly in the RTC reflected both the names, my lord. But later he filed a appeal before the assistant commissioner, wherein this RTC name is this plaintiff number, plaintiff is deleted. Lord, he established that he has separate, but as on the date of, he also this plaintiff says that, my lord, he is the karta of the family. But as on the date of purchase of this property, the father of both the plaintiff and dependents are alive. He is aged about 83. But he, the dependent number 1 is stated that the father is also taken all the family. He is maintaining the family at the age of 83. He was died in the year 1993 at the age of 93. But 83 aged, he has cannot be maintain the proper family at the age of, but this is not considered by the court below. Relationship is not disputed, my lord.
He was out of the family. He was staying elsewhere, not in the family of the plaintiff and other defendants.
In the evidence, my lord, he is admitted that he is also living in the family in the year
ಎಲ್ಲಿದೆ ಹಾಗಂತ?
1980.
Huh?
So he has given the in the cross examination. But he is established that he has produced several documents regarding the he has residing out of.
ಏನಂತ ನನ್ನ ತಂದೆ ಸಾಯವರೆಗೆ ನಮ್ಮ ಒಟ್ಟು ಕುಟುಂಬಕ್ಕೆ ನಮ್ಮ ತಂದೆಯೇ ಕರ್ತ ಆಗಿದ್ದರು ಎಂದರೆ ಸರಿ. ತಂದೆನೇ ಕರ್ತ ಅಂತಿದೆ, ನೀವು ನೋಡ್ರಿ ಇವನ್ ಕರ್ತ ಇವನ ಹೆಸರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡ್ರು ಅಂತ ಹೇಳ್ತೀರಿ.
Yes.
ಮತ್ತೆ ಅಡ್ಮಿಷನ್ ಇಸ್ ದೇರ್, ಫಾದರ್ ಇಸ್ ದಿ ಕರ್ತ. ಅದನ್ನ ನೋಡೇ ಅವರು ಬರ್ದಿರೋದು. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 19 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
ನೋಡಿದ್ದೀನಿ, ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
There is no mention of any other member of the joint family, including the father of the defendant number 1, Dodaya. That too, especially when Dodaya in the year 1983 was very much alive and was the karta of the family. The plaintiff has taken up the contention that these items were purchased by defendant number 1 as a karta of the family. But during the course of cross-examination of the plaintiff has admitted the fact that their father Dodaya was the karta of the joint family till his death. This is admission.
Admission.
ಮತ್ತೆ ನೀವ್ ಹೆಂಗೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತೀರಿ, ಇವನು ಕರ್ತ ಅವನ ಹೆಸರು ತಗೊಂಡ್ರು ಅಂತ. The same is reproduced here. This is the reasoning. ಕಂಟೆನ್ಷನ್ ಒಂದು, ಅಡ್ಮಿಷನ್ ಒಂದು. ಅವನ್ ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ಕೊಟ್ಟಿದ್ದಾನೆ.
ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್
ಅವನು ದುಡ್ಡನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ, ಆ ದುಡ್ಡನ್ನ ಯುಟಿಲೈಸ್ ಮಾಡಿ ಪರ್ಚೇಸ್ ಮಾಡಿದೀನಿ ಅಂತ. No documents with regard to the blending also. He was working in
GK earlier in the
company and also earlier he was in railway. Thereafter he left the job.
Except
first appellate court ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ ನೋಡಿ.
they say is the same appreciated by the same. Reappreciated the same. In paragraph 49 of the reappreciated all these things. Page 49 and paragraph 49.
Admittedly, the defendant number 1 was not the karta until demise of their father. There is no evidence forthcoming that defendant number 1 was managing the affairs of the joint family. Evidence records ಅದೆಲ್ಲ ತಗೊಂಡ್ರು, ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನೇನಿದೆ ಒಂದು ಸಪರೇಟ್ ಇನ್ಕಮ್ ಬಗ್ಗೆ. ಫಾದರ್ ತೀರ್ಕೊಂಡಿದ್ದ ಯಾವಾಗ?
93.
93. But this property was purchased in the year 1983 itself.
83 itself.
No ground sponsor.
But the only contention about the RTC is the joint in the plaintiff and defendant number 1 is continuing till the 1996, my lord. That is the not
ಚೇಂಜ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾನಲ್ಲ ಅವನು. ಎರಡು ಹೆಸರು ಎಬ್ರಿಗೆ ಹೆಸರು ಹೇಗ್ ಬರ್ತಾರೆ RTC? When the same deed was in
from
the
the
name
date
of
of purchase to till the 1996, it is continued both the name of the plaintiff and defendant number 1, my lord. Thereafter he has filed the appeal and obtained the cancel the same.
Good. This matter is listed for admission and I heard the counsel for the appellant. The factual matrix of the case of the plaintiff before the trial court while seeking the relief of partition included all the suit shell properties as joint family properties, and the respondent defendant number 1 took the specific defense in the written statement that he was working and separately earning from 1960 onwards earlier in the railway department, and thereafter he joined the company of GKW. And also even when he was working, he met with an incident and accident and lost his eye on 16/11/1972, and also he was getting the disability pension. And in support of his contention also he placed on record document exhibit D15, passbook of Bank of Maharashtra for having the amount to purchase the property, and also produced document exhibit D1 sale deed dated 3/35/1983, and content that the said property is a self-acquired property, and the trial court having considered the material available on record and also the admission on the part of PW1 in the cross examination extracted in paragraph number 19, wherein categorically admitted that till the death of the father was working as a karta. But contention was taken that defendant number one was working as a karta of the family. But the fact that father died in the year 1993, Udala?
ಹೌದು 93.
93, and property was purchased in the year 1963 in the name of the defendant number one. And having considered the document exhibit D15 and also the oral and documentary evidence as well as the admission on the part of PW1, trial court comes to the conclusion that item number 1 and 2 are the self-acquired property of defendant number 1 and 2, and granted the relief in respect of item number 3 to 9, and declined to grant the relief in favor of item number 1 and 2 in coming to the conclusion, answering the issue number 6 as affirmative, that the same is a self-acquired property of defendant number 1. Being agreed by the said judgment and decree, an appeal is filed in RA number 15 of 2018, and appellate court also having considered the grounds urged in the appeal memo, formulated the point whether the trial court is justified in dismissing the suit in respect of item number 1 and 2 as the self-acquired property of the defendant, and whether it requires an interference of this court. The appellate court also having reassessed the material available on record, particularly taking into note of the document of exhibit D1 sale deed dated 30/5/1983, who had purchased the property out of his self-earning, and also it is a specific case that he went out of the family in the year 1963 on account of his employment, and he acquired the properties. And property was also acquired in the year 1983, and the admission given by the PW1 herself in the cross examination that father was working as father was the karta of the family till his death, and the fact that father died in the year 1993 is not in dispute. And also appellate court having reassessed the material in paragraph number 49, particularly taking into the document of exhibit D22 to 28, which evidence the fact that he was an employee, and also exhibit D31 and 32, that is his terminal benefits from employment, and also taken note of the document of exhibit D15, the passbook, which according to the defendant number 1 evidence the salary which he was receiving as on the date of he acquired the properties in terms of exhibit D1, so as to shift the onus upon the claim made by the plaintiff. All these documents are taken note of, and though it is contended by the plaintiff that the defendant number 1 was the karta of the family, and the admission given by PW1 that father was working as karta till his death, and hence not accepted the case of the plaintiff that he was the karta and he had purchased the property in his name, was not accepted, and comes to the conclusion that property is acquired by the defendant, and the same is a self-acquired property of the defendant. The counsel appearing for the appellant in this argument would vehemently contend that both the courts committed an error in coming to the conclusion that defendant number 1 has not the karta of the family, even prior and subsequent to the death of the propositor Sri Dodaya. And appellate court also committed an error in coming to the conclusion that item number 1 and 2 are the self-acquired properties of the defendant. And both the courts have not considered the material and non-record in proper perspective, and hence it requires interference of this court, and hence rates this court to admit and frame a substantive question of law. Having heard the appellant counsel and also on perusal of material available on record, both the trial court and appellate court taken note of document exhibit D15 as well as the document of exhibit D22 ID card and exhibit D23 salary certificate and exhibit D24 ID card and exhibit D25 terminal benefits, as well as the contents of the document of exhibit D1 also taken note of, and the sale deed is in the name of the defendant. And apart from both the courts taken note of admission given by PW1 himself that father was the karta of the family till his death, and the fact that father died in the year 1993, and the item number 1 and 2 properties were purchased in the year 1963, 83. And when such admission was given, both the courts having taken note of evidence available on record, both oral and documentary evidence, not committed any error in coming to the conclusion that item number 1 and 2 are the self-acquired properties of defendant, and both documentary evidence as well as oral evidence supports the case of the defendant and rightly comes to the conclusion that defendant proved by answering the issue number 6 as the same is the self-accord property of defendant number 1 and 2. And when such being the case, when factual material was also taken note of and question of law also taken note of and considered the same in the first appellate court also, I do not find any ground to admit and frame substantive question of law, and hence no ground to admit. In view of the discussion made up, I pass the following order. Appeal is dismissed.
61. Prasanna Kumar P.
ಏನಾಯ್ತು? What happened? TCP ಏನಾಯ್ತು? ಆಮೇಲೆ ಏನಾಯ್ತು ಹೇಳಿ ಈಗ? Whether you have filed the charge sheet or not? TCP ಆಯ್ತು ಮೇಡಮ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ಯು ವೆರಿಫೈ ಅಂಡ್ ಸಬ್ಮಿಟ್ ಅಂತ. ವೈ ಹ್ಯಾವ್ ನಾಟ್ ಕಲೆಕ್ಟೆಡ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್ ವೆದರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್ ಆರ್ ನಾಟ್? Last occasion you are not present. In spite of it, I gave a direction. HCGP is directed to verify and submit anta. So the counsel appearing for the state again seeks time to verify and submit with regard to the status of other two separate cases registered by the state. The counsel appearing for the Lokayukta submits that already charge sheet is filed in two cases and in one case yet to.
ಒಂದ್ ಕೇಸ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಒಂದ್ ಕೇಸಲ್ಲಿ ಫೈಲ್ ಆಗಿದೆ, ಇನ್ನೊಂದ್ ಕೇಸಲ್ಲೂ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಏನೋ ಹೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ, ಇಲ್ಲೇನೋ ಒಂದು ನೋಟ್ಸ್ ಇಟ್ಟಿದ್ನಲ್ಲ ಮೇಡಮ್, ಏನಾಯ್ತು? ಇಲ್ಲಿದೆಯಲ್ಲ ನೋಡಿ, ಸ್ಪೆಷಲ್ ಲೋಕಾಯುಕ್ತ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಕೇಸ್ pertaining to criminal petition number 5918 of 24. Charge sheet already filed on 23/6/2025 and yet to give the special case number, and also in petition pertaining to criminal petition number 6251 of 24. Investigation is completed and awaiting for the FSL report, and already he has given instructions to file the charge sheet awaiting the FSL report and yet to get the number of special case. And however, he submits that in criminal petition number 6224 of 24, yet to complete the investigation. Complete the investigation. Really?
Please, my lord, may I submit judgment? Regarding maintainability of the petition, when charge sheet is filed, the first judgment of the Supreme Court, relevant portion your lot 2011 7 SCC 59. Relevant portion your lordship will find at paragraph number 16 on page number 5. Read, my lords. Thus, from the general conspectus of the various sections under which the appellant is being charged and is to be prosecuted would show that the same are not made out even prima facie from the complainant's FIR. Even if the charge sheet had been filed, the learned single judge could have still examined whether the offences alleged to have been committed by the appellant were prima facie made out from the complainant's FIR, charge sheet, documents, etc. or not. The second judgment your lordships will find on page number.
ಆಯ್ತು, ನಿಮಗೆ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದಾರಾ ಅವ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು?
ಕೊಟ್ಟಿಲ್ಲ, ಕೋರ್ಟ್ಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ರಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದಾರ್ರಿ.
A draft charge sheet on that arguments have been completed. Both the sides have submitted arguments. Now your lordship posed the
on the
question.
charge sheet material you have not addressed any argument.
We have argued, they've given certain documents.
That's what when I gone into the papers, nothing you made any submission regarding the charge sheet materials filed by them.
I'll argue, my lord.
ವಾಲ್ಯೂಮ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡ್ರಿ ಅದು ಮೇಡಮ್. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ 2 ಬಂಡ್ಲು ಕೊಟ್ಟಿದ್ದಾರೆ ಚಾರ್ಜ್ ಶೀಟ್ ವಾಲ್ಯೂಮ್, ಕೆಳಗಡೆ 2 ಇದೆಯಲ್ಲ, ಅವು 2 ಬಂಡ್ಲು. ಹೋಗ್ಲಿ, ನೀವೇನಿದ್ದಾರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರಿ ಅಂದ್ರಲ್ಲ, ಏನ್ ಹೇಳಿದಿರಿ ಆ 2 ಬಂಡ್ಲ್ಸ್ ಮೇಲೆ ಹೇಳಿ?
Those volumes have not been furnished.
ಕೊಟ್ಟಿದಾರ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್.
We have served you. Served and
3
ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
I'll verify.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ even in spite of FIR, you have to address an argument on these materials also.
Now, question is whether an petition filed seeking quashing of FIR in the during its pendency, if charge sheet is filed, what happens to the petition?
ಯಾಕೆನೆ ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, even if the charge sheet had been filed, learned single judge could have still examined whether the offences alleged to have been examined by the appellant were prima facie made out from the complainant's FIR, charge sheet and documents etc. or not antide. You have to make submission on charge sheet also.
Regarding this petition, I'll make on charge sheet, my lords. Now, may I request this honorable court to kind of look at page 24. para 14, latest judgment of 2023,
ಹೇಳಿ ಏನು?
para 14. This being the factual drop,
ಯಾವ್ದು? ಯಾವ judgment?
page 24, judgment starts from page 19.
24.
Relevant portion on 24, judgment starts on page 19.
19.
Page 19.
ಹೇಳಿ.
Relevant portion 24, paragraph number 14. This being the factual backdrop, we may note at the very outset that the contention that the appellant's quash petition against FIR was liable to be dismissed in any event as a charge sheet in relation thereto was submitted before the court and taken on file needs mention only to be rejected. It is well settled that the High Court would continue to have power to entertain and act upon a petition filed under section 482 to quash the FIR even when the charge sheet is filed by the police during the pendency of such petition. This principle is reiterated and so on. So now, my lords, your honorable, this honorable court's order, which is in my appeal memorandum, which starts at page 58. The relevant portion, if I may request this honorable court to kindly have a look at
ಯಾವ್ದು?
your appeal memorandum, ali, petition.
Earlier.
Your lordship's
Earlier
order.
order.
Your lordship's
ಅದೆಲ್ಲ
order.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರಿ last time.
Adralli, there is an observation by your lordship that firstly, there is no complaint for these FIRs. Second, that all these FIRs are second FIRs which are initiated by the ACB.
That is with regard to other two cases registered by the state.
Please, Lord.
Please,
State. And subsequently, they have filed a charge sheet
please.
by the Lokayukta police. That is what the
So
same has
second-
been observed. No dispute with regard to the observation is concerned.
Those two
Now their
FIRs,
contention is that investigation is completed. Now they have filed the charge sheet and they are relying upon 2 volumes of documents.
insofar as this,
What is the?
insofar as this petition is concerned, that is 5918, they have filed charge sheet which is placed on record. So this,
ನೋಡ್ರಿ ಅದ್ ನೀವು ಕೊಟ್ಟಿದಿರಲ್ಲ ಅವ್ರಿಗೆ ಅದರ್ ಸೈಡ್ಗೆ ಬರೀ ನಮ್ ಕೋರ್ಟ್
We have
ಮಾತ್ರ
sorted.
ಹಾಕಿದ್ರೆ ಏನು?
ಸರ್ವ್ ಮಾಡಿ ಕೋರ್ಟ್ ಕೊಟ್ಟಿವಿ.
ಶುರು ಮಾಡಿದಿರಾ?
ಮಾಡಿ
Document ಇದೆಯಾ?
I do not
ನೋಡಿ.
have a copy with me.
They are also not having any copies. You verify whether you have served the copy
Please,
on them
will
or not.
I'll verify.
Now, because he relies upon some of the documents, even when the petitions are filed for quashing of FIR also, if charge sheet is filed,
Please.
court has to look into the materials of charge sheet also ಅಂತ ಹೇಳ್ತಾರೆ.
I'll
You have to
verify.
give an opportunity for them to, what are the materials you have placed
Verify,
before the
Lordship.
court?
I'll verify.
Let them meet the case.
Please, Lordship. I'll
In
verify.
in case of charge sheet also,
If it is not served, I'll make sure it will be
you
served.
furnish it.
Please.
ಯಾವಾಗ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀರಿ ಮೇಡಮ್ ನೀವು?
May I submit, my lord?
ಹೇಳಿ.
Insofar as other petitions are concerned, this, there is
ಎಲ್ಲ
no,
ಎಲ್ಲದು ಕ್ಲಬ್ಡ್ ಮ್ಯಾಟರ್ ಒಟ್ಟಿಗೆ ತಗೊಂಡಿರೋದು ಒಟ್ಟಿಗೆ ಕಾಮನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಡಿಕ್ಟೇಟೆಡ್ ಬಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ 2 bundles of records ಐ ವಾಸ್ ಅನೇಬಲ್ ಟು ಡಿಕ್ಟೇಟ್ ದಿ ಆರ್ಡರ್ಸ್. ಆ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಏನ್ ನಾವು ರಿಲೇ ಮಾಡಿದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನಿಮ್ಮಲ್ಲಿ ಏನು ಮೆನ್ಷನ್ ಏನು ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೆ ಈಗ ಅವ್ರ ಪ್ರಕಾರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತ
I do not have
ನಿಮ್ಮ
a-
ಪ್ರಕಾರ ಈಗ ನೀವು ಸೈಟೇಷನ್ಸ್ ಕೊಡ್ತೀರಿ ಅದ್ರ ಪ್ರಕಾರ ಅದನ್ನು ಲುಕ್ ಇಂಟು ಅಂತಂದ್ರೆ they have to furnish documents in case if they have not
to
furnished.
furnish on that, I'll. make my
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾರೆ ಫಸ್ಟ್ ನೀವು ವೆರಿಫೈ ಮಾಡಿ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ ಅಂತ. ಅವ್ರೇನೋ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಏನಾಯ್ತು ಹೇಳಿ ನೋಡಿ. The counsel appearing for the Lokayukta also submits that the charge sheet which is filed in criminal petition number 5918 of 20 ಯಾವ year ಇದು 24
24.
24 is already furnished and counsel for the petitioners would submit that no such documents are furnished and hence if such charge sheet materials are not placed, not served on the counsel, Lokayukta counsel is directed to furnish the same. If it is already furnished, the counsel for the petitioner makes submissions on that, the charge sheet. ಇನ್ನೊಂದ್ರಲ್ಲೂ ಏನೋ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೀವಿ ಅಂತಂದ್ರಲ್ಲ ಅದ್ರದ್ದು ಮೆಟೀರಿಯಲ್ ನೀವು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. 6251 of 24 ಆಲ್ರೆಡಿ ಕಂಪ್ಲೀಟೆಡ್ ಅಂತಾನೆ ಹೇಳ್ತಿರಲ್ಲ ನೀವು. ಅದು ಕೊಡ್ಬೇಕು. ನಮ್ಮ ಮುಂದೆ ನೀವು ಕೊಟ್ಟಿಲ್ಲ. ಇದ್ರೆ ಅದನ್ನು ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ದಿ ಕೌನ್ಸಿಲ್ ಹೇಳಿದ್ನ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಸ್ಟೇಟ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ವೆರಿಫೈ ಅಂಡ್ ಸಬ್ಮಿಟ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 10/7. ಈ ನೋಟ್ಸ್ ಅದರಲ್ಲೇ ಇಡಿ.
Final hearing matter 64 Vide Sharma.
ಏನ್ರಿ 24 ಮ್ಯಾಟರ್ ಈ ಕಾಪೀಸ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಅಂದ್ರೆ ವೈಕ್ಯಾನ್ ಶರ್ಮಾ
64
ಏನೋ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತಲ್ಲ ನೀವು?
ಹೌದಾ? ಐ ಆಮ್ ಸರ್ಪ್ರೈಸ್ಡ್. ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ. ಇಲ್ಲ ಕೊಡ್ತೀನಿ, ನನಗೆ ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡ್ಬೇಕು. That's a case regarding remanding.
Learned counsel for the respondent seeks time. Learned counsel for the appellant says no objection. List the matter. ಅವತ್ ನೋಡಿದ್ರೆ ಟೈಮ್ ಕೇಳಿರಿ, ಇವತ್ ಬಂದು ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ನಾವ್ ಯಾವ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ವಿ ಯಾವಾಗ?
ನನಗೆ
ಯಾವತ್ತು ಕೇಳಿದೆ? 11/6. ಏನಾಯ್ತು 11/6 ಅಲ್ಲಿ? 11/6 ಅಲ್ಲಿ ಆ ರೀತಿ ಏನಿಲ್ವಲ್ರಿ? ನೀವು ಬರೀ ಟೈಮ್ ಕೇಳಿದ್ರಿ, ಅವ್ರು ನೋ ಒಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ರು, ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್.
ಮೇಕ್ ಒಂದು ಸಬ್ಮಿಷನ್.
ಕೊಟ್ಬಿಡಿ, ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ, ನಾನು ಕಾಪಿ ಕೊಡ್ತೀನಿ. If he really wants time, let him ask for time. But interim order may be extended.
Counsel for the respondent submits that he has not received the MSA copy and hence appellant counsel is directed to furnish the copy of the
ಅಲ್ಲ, I will furnish order clear ಮಾಡ್ತೀನಿ, ಕೊಡ್ತೀನಿ.
MSA forthwith. ಕೊಟ್ಬಿಡಿ ಒಂದು forthwith.
ಗೊತ್ತಾಗೋದಿಲ್ಲ, within a week.
Interim order granted earlier is extended till next date of hearing. List this matter on 10/7.
ಯಾವಾಗ?
10/7. Copies ಕೊಟ್ಬಿಡಿ immediate.
ಕಾಪೀಸ್ ಕೊಡ್ತೀನಿ.
Yes, 65.
Within a week ಅಂತ ಹೇಳ್ಬಿಡಿ, ಇವತ್ತು ಆಗೋದಿಲ್ಲ.
Within a week ಅಲ್ಲ, forthwith ಅಂತ ಹೇಳಿದಿ. ನಾನು ಯಾವ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ. ನಾಳೆ ನಾಡಿದ್ದಲ್ಲಿ ಕೊಡಿ.
ನಾಳೆ ನಾಡ್ದಲ್ಲಿ ಕೊಡ್ತೀನಿ. ಸರಿ, ಇವತ್ತು ಆಗಲ್ಲ, ಹಾಗೆ ಹೇಳಿದೆ. ಕೊಡ್ತೀನಿ.
ಇವತ್ತು ನೀವು ಈಸಿಲಿ ಇದೀರಿ, ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗುತ್ತಾ?
ಐ ಆಮ್ ಸಾರಿ, ಇಂತ ಟೆಕ್ನಿಕಲ್ ಸಣ್ಣದಕ್ಕೆ ನಾನು ಜಗಳ ಆಡಲ್ಲ.
Non-compliance of office objection raised on in IA number 1/22, counsel filed by the respondent. ಏನ್ರಿ ಅದು? ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವೇನು IA ಹಾಕಿದಿರಿ? 1/22 filed by the counsel for respondent ಅಂತಿದೆ. ಏನು IA ಹಾಕಿದಿರಿ? ರೆಸ್ಪಾಂಡೆಂಟ್ ರೀ, ನಿಮ್ಮನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು, ಅದಕ್ಕೇನೆ. ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿ ಮೇಡಮ್?
Provision of law correct ಆಗಿ ಬರ್ದಿಲ್ಲ ಅಂತ ಇರೋದು.
ಏನ್ IA ಹಾಕಿದಾರೆ ಅವರು? 1/22 ಏನದು IA? What is the prayer in the IA ರೀ?
Not to sell the property belonging to the estate.
Not to sell ಅಂತನ. Office objections, why you have not complied it? 22. ನೀವೇನ್ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಈಗ? ಅರ್ಲಿಯರ್ ಬೇರೆಯವ್ರು ಇದ್ರಾ? ಏನೋ 226 ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ರಿ ನೀವು ಎಲ್ಲದಕ್ಕೂ ರಿಟರ್ನ್. ಯಾರೋ ದಿಲ್ರಾಜ್ ರೋಹಿತ್ ಸಿಕ್ವೇರ, ನೀವೀಗ ಬೇರೆಯವ್ರ? ನೋಡಿ, ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ submits that the application is filed by the other advocate earlier and now he has filed the wakalat with NOC and seeks 2 weeks time to comply with office objections on IA number 1/22 and hence list this matter on 10/7. Then disposed matter or pending?
10/7 is a bit personally inconvenient for me. 10/7 is a little inconvenient.
Which date convenient to you?
Any day other than the 10th, because I got
11/7.
I got a date given matter on 10/11.
11/7.
66. Proffel de Costa.
Acceptance of verifying affidavit dated
Petition
21/8/23 by counsel for petitioner. Exhibit and depositions are marked in will is kept in safe custody. What is that acceptance?
It is for petition for probate, Your Honor. The will of the deceased is dated 29/4/2003.
What is the affidavit you have filed, madam?
Evidence of the witness, Your Honor, the first witness to the will. I have filed and marked the signatures of the deceased in the will as well as in the witnesses.
Evidence has to be recorded by the.
It's
CPC.
recorded, my lord.
Already recorded?
Yes, my lord.
Then why you have filed one more affidavit? Acceptance of verifying affidavit dated 21/8.
That was verifying affidavit, my lord.
Why you have filed verifying affidavit now?
Their office had asked me, they've said it is an objection compliance and they've asked for verifying affidavit, my lord.
Verifying affidavit dated 21/8/23. Yenad verifying affidavit?
Verifying for petition, my lord, to be filed along with the petition.
Well conversant with the facts of the case and hence competent to swear to this affidavit. I submit the statement made by the second petitioner and myself in paragraph 1 to 7 of the above petition are true and correct to the best of my knowledge, information and belief. ಯಾಕೆ ಇದು ಅರ್ಲಿಯರ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ? ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗ Earlier you have not filed verifying
I have
affidavit?
not filed, Your Honor, because in the probate matters, there is a specific format by the act itself.
Now
And,
you have, now you have already examined witnesses?
yes, I have examined the first witness.
Yourself also examined?
The,
Yourself also examined?
the petitioner has not been examined, my lord.
Yeah, then petitioner also to examine you before the commission, before the CPC, original death certificate.
Here the petitioners are the executors of the will and she is the wife of the deceased, my lord.
Madam, once you filed a petition, you have to lead evidence and give evidence on oath. Have you examined yourself?
I have not
or
examined the petitioner, my lord. I
Only you
have
have
examined the
Only you have
witness,
examined one of the witness?
witness to the will, my lord.
Witness to
Because
the
I
will.
need to prove the will.
Thoroughly. The counsel appearing for the petitioner submits that verifying affidavit is filed on 21/8/23 and the same is taken on record. Since earlier, no such verifying affidavit was filed. And hence petitioner is directed to appear before the CPC on other one date kodi madam. ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ವಲ್ಲ, ಯಾವ ಡೇಟ್ ಹಾಕಿದ್ವಿ?
8/7 it was given.
8/7.
Previous case I has for
that is
CPC.
Your case
Yes,
only?
yes, my lord.
Then you go on that day itself.
Yes, my lord.
8/7/23. And examine. Petitioner ಏನು herself ಅಥವಾ ಏನು?
The petitioner is Mrs. Shifali, my lord.
Herself.
Shifali Alvarez.
Before the CPC.
My lord, there is
And-
one inconvenience.
And mark any other documents in support of the case of the petitioner.
My lord, the Shifali Alvarez is at present in Australia, my lord.
Then you are going to examine whom?
If it is,
Helen Mary Alvarez?
yeah, she is in Mangalore.
And now you can examine her.
Okay, much better.
Any one of the petitioner
Yes,
must be
my lord.
examined before the
Yes, my lord.
CPC. You
Yes.
can examine any one of them.
Yes, my lord.
Now you have filed the verification affidavit belongs to whom?
The first witness, my lord.
First petitioner.
First witness.
Now you pointed out that a verifying affidavit is filed before the
Of
court
the first,
of the
first petitioner.
first petitioner.
Yes, my lord.
Anyhow, you examine any one of the petitioner.
Okay, much better. 8/7, my lord.
8/7.
Much obliged.
Place this matter before the CPC on 8/7.
67 and 68, Prakash Image.
Prakash MH, MR Hirematad.
For the appellant, senior has been held up in the part-heard matter in Kotal 25. Matter may be taken up next week, Your Lordship.
Next week. Third. Appellant counsel submits that the counsel is on record is held up in other court and counsel for the respondent is also absent. And hence list this matter on 10/7, madam. 10/7. If respondent counsel doesn't appear in the next date of hearing, matter will be heard in his absence.
Obliged, Your Lordship.
69, Subramani GN,
Subramani GN,
GS Prasanna
GS
Kumar.
Prasanna Kumar.
Appear for the appellant.
With NOC. Yes, counsel. Paper book area, code. What is the substantive question of law?
Lord, whether the courts were correct in decreeing the suit beyond what was purchased in the sale
Plaintiff
deed.
filed the suit for injunction based on title. Was the plaintiff entitled to claim relief of injunction in respect of larger area than what was mentioned in the title deed?
Yes, madam. Title deed, they claimed that they had only 40 into their own claim, my lord. Kindly the plaintiff.
40 into
30.
30.
30. Then in the schedule, they say 40 into 33.
40 into 33.
40 into 33. But claiming in the schedule, what they say is 40 into 33, I have already constructed a house. Behind that house, there is another 6 feet. 40 into 33 is already constructed. Side of that, western side of that house, there is another 6 feet, vacant space. That is also decreed. That is why the question came to be framed. The entire property, including the house, the entire property belonged to the defendant. One side he had sold it.
What
40
happened in first appellate court?
Well, first of all, also they said the same thing, my lord, because
Confirm the judgment.
confirm the
trial court.
judgment.
Hmm.
Confirm the judgment,
Now,
they have, actually the court has confused, the first appellate court has totally confused regarding the measurements and the way it is being done, my lord. That is why it has resulted in that way. Kindly if I may point out, my lord, kindly I may be permitted to point out in the first appellate court first, then I will go to trial court. Ink page 25, internal page 7 of the first appellate court may be taken out. To substantiate our claim, kindly, here what is being said, my lord, there are two deeds have been mentioned.
Paragraph?
35, paragraph 21, two deeds have been mentioned. RA 15 of 28. 21, there are two deeds mentioned. One is the registered sale deed, 35/1996. The second one is only an agreement between the plaintiff and the defendant, wherein the plaintiff was supposed to give, what is there, the compound wall on the northern side. For that, the defendant was supposed to give her 3 feet additional land, which the southern side, it was supposed to be given to the plaintiff. The plaintiff did not do that. For that reason, defendant first filed the suit that she has already, we had entered into an agreement like this. Either director to give the compound wall or director to cancel that agreement. My land will remain with me.
What happened?
That suit is still pending.
Pending.
That suit is still pending. After 2 years after filing of that suit, this suit comes to be filed, wherein the plaintiff itself, kindly the schedule may be seen, Madam, my lord, for a moment.
Both suits has to be clubbed together.
ಮಾಡಬೇಕಿತ್ತು ಸ್ವಾಮಿ, ಅಲ್ಲ ಅವ್ರು ಮಾಡಿಲ್ಲ. ಅದನ್ನ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಈ ರಾಮಾಯಣವೇ ಇಲ್ಲ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಯಾರನ್ನ ಒಬ್ಬ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು.
ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಆ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇವಾಗೂ ಇದೆ. ಅದ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಪ್ರಾಬ್ಲಮೇ ಇಲ್ಲ ಅಲ್ಲಿ.
ಏನ್ ಮೇಡಮ್, ಇದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಅಲ್ಲ, ಲೆಟ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಬೋತ್ ದಿ ಸೂಟ್ಸ್ ಟುಗೆದರ್. Where is the Prasanna Kumar? Anwar. ಅದೇ ಅದೊಂದೇ ಇಶ್ಯೂ ಈಗ. It can be. Heard in part, counsel appearing for the respondent seeks time on the ground that counsel on record is unwell. And hence list this matter on the other one. Short question, madam. ಒಂದು 10 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸಬಹುದು. ಏನ್ ಹೇಳಿ?
In the meanwhile, if I may permitted to file an application for appointment of commissioner, I will do that in this application.
ಏನ್ appointment of commissioner ಆಗ್ಬೇಕು? ಇರೋ ಕೇಸಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡೋಣ.
ಬಸ್
ಮತ್ತಿಲ್ಲ ಮತ್ತೆ ಅದಕ್ಕಿನ್ನೊಂದು ಟೈಮ್ ಯಾಕೆ?
ಬಸ್ ಮಚ್ ಅಬ್ಲೇಜ್.
ನಾನು ಹೇಳೋದು 2 ಸೂಟ್ ಇದೆ.
ಹೌದು ಸುಮಿ.
Both the suits to be considered
together. ಅದು ಹಂಗೆ ಮಾಡ್ಬೇಕಿತ್ತು, ಅದು ಬೈ ಮಿಸ್ಟೇಕ್
between them.
Yes sir.
There is an agreement.
Yes.
Already they have filed a suit for seeking the relief with regard to the agreement is concerned.
Yes sir.
ಒಟ್ಟಿಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಿತ್ತು. ನೋಡ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ಡಿಸೈಡ್ ಮಾಡೋಣ ಅಂತ.
No.
In respect of the in between plaintiff and defendant, according to him there is an agreement.
Yes.
In respect of that agreement, your client already filed a suit. ಅದರಿಂದ ನೋಡಿ ಹೇಳಿ, ಸೇಮ್ ಆದ್ರೆ ನೋಡಿ ಹೇಳಿ, ಬೇರೆ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡಿ. ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 7/7.
Much obliged. But 8
ಬೇಕಾ? ಆಯ್ತು, 8/7.
Much obliged.
70 ಶಿವರಾಮ್ ಭಟ್ HP ದೇವರ.
Connect along.
ಏನ?
Connect along with
ದಲ್ದಲೇನೆ arising out of common judgment.
Similar.
ಸೇಮ್ ಡೇ ಆಗ್ಲಿ, ಬಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇರೆ ಬೇರೆನಾ? ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಬೇರೆ ಬೇರೆನಾ? ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಕಾಮನ್ ತಗೊಳ್ಳಿ ಹಂಗಾರೆ. both counsel submits that other connected RSS are pending before the court, that is 379 of 21, 380 of 21, 381 of 22. And hence registry is directed to post all these RSS together on
First week of July.
on 10/7.
71.
Connected alla madam, post the matter
Along with.
on same day ಅಷ್ಟೇ. ಈಗ ಬೇರೆ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ 71 ಅರ್ಜೆಂಟ್ ಮೇಡಮ್, ಅದು ಉಳಿದೆ ಅಲ್ವಾ?
ಇಲ್ಲ ಸರ್, 72 ಅರ್ಜೆಂಟ್, 73 ಬಂದಿದೆ.
73 ಒಂದೇ ಇರೋದು ಈಗ. ಆಯ್ತು.
ಶಶಿಕುಮಾರ್ ಜಿವಿ,
ವಿಘ್ನೇಶ್ವರ ಯು,
ಯು.
appointment of court commissioner along with counter statement. ಯಾವ್ದು ಹೇಳಿ? ಇಷ್ಟೇ ತಗೊಳ್ಳಿ, ಒಂದೇ ನಿಮಿಷ. ತಗೊಳ್ಳಿ. ಇಲ್ವಾ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್? ಏನಿದೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ಈಗ? ಸೂಟ್ ಓನ್ಲಿ ಫಾರ್ ಇಂಜಂಕ್ಷನ್, ಡಿಕ್ಲರೇಷನ್ ಇದೆ. For want of time, list this matter on 25/6/25.
Land where server number 25. Whereas it is shown as 26 in that
Sale deed.
They want that to be
Corrected.
without seeking for relief of
Rectification.
to be declared that their land where server number 25.
Decreed. Suit of the plaintiff is declared. No, suit of OS 868 is dismissed. Declared that plaintiff Madhavaya is in possession of land in survey number 25, mentioned as survey number 26/1 in the revenue records, measuring 3 acres situated at Uttarahalli, Manavartekal, Uttarahalli, Bangalore Taluk. Concerned authorities are hereby directed to rectify in the revenue records the correct survey number of the plaintiff's property as 25 instead of 26/1, and correct survey number of so and so. The defendant is permanently restrained from interfering with the plaintiff's peaceful possession and enjoyment of the same. Appeal ಅಲ್ಲಿ ಏನಾಯ್ತು? Appeal allowed and reversed.
Rectification period. The suit not made.
Last time for want of time. Third, appellant counsel is absent and counsel for the respondent is present. If the appellant counsel doesn't appear in the next date of hearing, the appeal will be dismissed. Dismiss this matter on
10/7.
10/7. ಅದಿಲ್ಲ. ಯಾವ್ದು ನಿಮ್ ಮ್ಯಾಟ್ರಲ್ ಏನೋ ನಿಮ್ಗೆ ಹೇಳಿದೀವಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ರಿ, ಮತ್ತೆ ಯಾಕೆ ಬಂದಿದ್ದೀರಿ? ನಿಮಗೆ ಹೇಳಿದೀವಿ ಅಂದ್ರಲ್ಲ ಅವರು. ಮಧ್ಯಾಹ್ನ ನಿಮಗೆ ಮಾಡಿದ್ರ 1:15 ಬಂದು ಟೈಮ್ ಕೇಳಿದ್ರು, ಅದರ್ ಸೈಡ್ಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ದೆನ್ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂದೆ. ಮಧ್ಯಾಹ್ನ 2:30 ಬಂದು ನಿಮಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀನಿ. And also I made it clear, have you intimated the R2? They said that not yet, but going to intimate them ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ನೋಡಿದ್ರೆ ಇಲ್ಲ. ನಿಮ್ಗೆ ಹೇಳಿಲ್ವಾಗಾರೆ ಏನಂತ? ಏನೋ 2:30ಗೆ ನಿಮಗೆ ಡೇಟ್ ತಗೋತೀವಿ ಅಂತ ಹೇಳಿದ್ರಾ? ಸರಿ ಆಯ್ತು. ಆಯ್ತು, 10/7 ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡಿ ಡೇಟ್. 10/7. ಏನ್ ನೋಡ್ರಿ ಅವ್ರದ್ದೇನು ನೋಡ್ರಿ ಪಾರ್ಟಿ ಯಾರ ಅಂತಾರೆ. ಯಾವ ಕೇಸಲ್ಲಿ? ಓ ನಿಮ್ದೇ ಕೇಸಾ? ನಿಮ್ ಕ್ಲೈಂಟ್ ಏನ್ರಿ ಅವರು? ಹಾ. ತಗೊಳ್ರಿ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಅಂದ್ರೆ. ಬಟ್ ನೀವು ಯು ಆರ್ ನಾಟ್. I told them to intimate you, but according to you, they have intimated you. ಮಾಡಿ ಹೇಳಿದ್ರಲ್ವ ಟೈಮ್ ತಗೋತೀವಿ ಅಂತ. ಹೌದು. ಹಾ. ತಗೊಳ್ಳಿ. The counsel appearing for the R1 submits later ಅಂತ ಹಾಕ್ಬಿಡಿ. Later. The counsel appearing for R1 submits that during the lunch time made a mention by the appellant counsel that going to move for an adjournment, and he in turn told them that what time going to move the matter for adjournment, that he is having a matter at portal number 2 and he will come to court, but not positively mentioned the timings, but they took the adjournment in his absence. And the party for and party, that is R1, is also present and objects for granting of time. In view of the submission of the respondent number 1, respondent number 1 counsel list this matter on. You have to submit code. ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. 10/7 ಬೇಡ, ಈಗ ಬೇರೆ ಕೊಡಿ. ಅವ್ರು ಬಂದು ಏನೋ ಹೇಳ್ತಾ ನಾನು ಏನೋ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅವ್ರಿಬ್ರು ಒಟ್ಟಿಗೆ ಇದ್ದಾಗ ಜಗಳಾಡ್ಲಿ ಇಬ್ರು. ಹಾ, ಯಾವಾಗ? ಮತ್ ನೀವು ಅದು ಹೇಳ್ತೀರಿ ಇದು ಹೇಳ್ತೀರಲ್ರಿ. That's why I asked you whether they have mentioned about seeking of an adjournment ಅಂತ. ನೀವು ಎರಡೂ ಹೇಳೋದಿಲ್ಲ. ನಾನು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದೆ ಅಂತ ನೀವೇನು ಹೇಳೋದಿಲ್ಲ. ನೀವು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ. ನಾನ್ ಟೈಮು ಎಷ್ಟು ಗಂಟೆಗೆ ಮೂವ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದೆ ಅಂತ ಹೇಳ್ತೀರಿ. ಮತ್ತೆ ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? 10/7 ಇರ್ಲಾ ಅಥವಾ ಬೇರೆ ದಿವಸ? ನನಗೇನಿಲ್ಲ, ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ನಾನು ನಾಳೆ ಎಲ್ಲ ನಾಡಿದೆ ಹಿಯರ್ ಮಾಡ್ತೀನಿ. ಹಾ, ನಿಮ್ಮಿಬ್ರು ಜಗಳದಲ್ಲಿ ಕೋರ್ಟ್ ಅನ್ನು ಬ್ಲೇಮ್ ಮಾಡೋದ್ ಬೇಡ. ಆಯ್ತು ಬಿಡ್ರಿ, ಯಾಕ್ರೆ ಏನೋ ಮೆನ್ಷನ್ ಮಾಡೋದ್ ಬೇಡ. 10/7 ಅಷ್ಟೇ ಇರ್ಲಿ. ಇನ್ಮೇಲೆ ನಾನು ಯಾರಿಗೂ ಯಾವ ಇಬ್ರು ಲಾಯರ್ಸ್ ಇಲ್ದವ್ರು ಡೇಟೇ ಕೊಡೋದಿಲ್ಲ. ಹ್ಮ್.
ಇದೊಂದು ಮತ್ತೆ ರಿಸರ್ವ್ ಮತ್ತೆ ನೆನ್ಪಿಟ್ಕೊಂಡು ಹಾಕಿಸ್ಬೇಕು. ಯಾವತ್ತು ಇಲ್ಲ ಕಳಿಸಿ ಮತ್ತೆ ತರಿಸೋ ಬದಲು ಇಲ್ಲೇ ಇಟ್ಕೋಬೇಕಲ್ವ, ರಿಸರ್ವ್ ಆಗಿದೆ. ಎಷ್ಟೇ ಹೌದು, ನಂಗೆ ಅದೇ ಭಯ. ನಾನಂತೂ ನೆನ್ಪಿಸಲಿಕ್ಕೆ ಎಷ್ಟೇ ಗೊತ್ತೇ ಇಲ್ಲ. 10/7 ಅಷ್ಟೇ 61.
61. ನೀನೇ ನೋಡಿದ್ರೆ ಲೇಟ್ ಆಗೋಯ್ತು ಇವತ್ತು ಬೇಗ ಆಯ್ತು.